I'm sorry, I apologize to the court.
That's all right. I'm sorry if I interrupted, but
I'm trying to fight for my client here, Judge. It's not you, it's not the court. I respect both.
we have limited time, and I'm trying to make sure I understand, so bear with me. But the idea is, we have an ongoing investigation, an officer deems that it's not being done right, that his or her rights are being violated, and so we have this procedure whereby the officer can demand a compliance review panel with the idea, under the statute, that the panel, not being inappropriate, biased, or any other problem with it, will come up with the right decision, report that to the agency head, and if it's warranted, the investigator will be removed. Isn't that the basic
You get that.
reason for this?
Can I catch a breath and let Mr. Abraham respond to that question, Your Honor?
Sure.
Thank you, Your Honor. That's what you put your finger on, Your Honor. I think is the language is exactly as you read, and that particular portion, if an investigator is found to have violated his rights, that would be grounds for removal of that officer. But and I think that Mr. King was trying to allude to, if you look down at the next sentence underneath that language that you read, it says all the provisions of Chapter 838.022 shall apply to this part. That's in reference to the Compliance Review Board's review.
Which statute?
832.
Yes, I do.
You may. And I'll allow the court to find it in its report.
I have one for you. Your Honor, would you like a copy of the statute that Mr. McKinnon is about to refer to? May I approach? Actually, here it is. Thank you.
Thank you. If Your Honor, if you would look in reference to 838.022, which applies to that part of referring to the statute that you read regarding the compliance review committees, it says it is unlawful for a public servant with corrupt intent to obtain a benefit for any person or to cause harm to another, to falsely or cause another person to falsify any official record or official document, to conceal, cover up, destroy, mutilate, or alter any official record or official document, or cause another person to perform such an act.
So that would be included in the intentional misconduct.
That's correct. And Your Honor, that's that we.
But this is a criminal statute, isn't it?
And it's incorporated
Let me
in the
try
compliance.
to just talk one at a time. if you
Yeah.
could. That's a criminal statute, 838.022.
Well, Your Honor, it is a statute which sets forth that is certainly a crime, but it is also incorporated into the statute which you just read about regarding the.
So the answer to my question is yes, but then you would add, but as we have just noted, it is incorporated in 112.534.
That's correct, Your Honor.
Now, but what is incorporated for the purpose of doing? Is it to provide us with instances of what would be misconduct, which would require the removal of the investigator and a potential report to the Criminal Justice Standards and Training Commission?
Well, Your Honor, if by its plain language, Your Honor, I read it as in under the statute 838.022, it also incorporates public servants. If you'll see under section 2A, the term public servant, it says it identifies is not a candidate who does not otherwise qualify in it as a public servant, but it talks about but it speaks to the term public servant. So it's much larger than the word investigator. The statute uses public servant, much broader term than the term investigator. And the legislature very specifically incorporates, it says it applies to this part. So
what I'm trying to find out is in what way does it apply to this part? For the purpose of what?
well, Your Honor, I think our opinion is that based on its plain language, being incorporated in that statute, that the Compliance Review Committee would have the authority not only to make findings as it relates to investigators, but make findings of violations intentional violations of public service. Otherwise, we would submit that the language be superfluous.
Well, the compliance review panel might have that authority or might not. We could cogitate and think about that. Please, anyone who's come in, feel free to find any seat that's available. We're happy to have you. But they could do that, but it doesn't require them to do that.
It doesn't, Your Honor. It doesn't require the Compliance Review Committee make any findings. But what it requires is that the process be allowed. The argument...
But the process be allowed for the purpose of... Finish that sentence, please.
For the purposes of investigating the agency for violations of the section, and if an investigator is determined to have intentionally violated, to remove that investigator. And
from the investigation of that officer.
Of that officer.
All right.
And in addition to that, it says it also incorporates Chapter 838.
We just talked about that.
We
Now,
just talked about.
if there is no ongoing investigation of that officer, isn't all this moot?
No.
No, Your Honor, and
Mr.
that...
Kenny just said you're supposed to say no.
Your Honor, that is the most interesting argument, Your Honor. What we have here is a clear, and the documents will show, it was a clear demand for the rights under the statute. Whether they agree with the violations occurred or didn't occur, of course, that's for the Compliance Review Board if they get the opportunity to hear it. But the demand was made, it was made in writing. So what their argument is, Your Honor, if we just fire him, the statute doesn't apply to us. And if you apply that standard to all law enforcement, the statute's new. They could violate all the rights they like, and if they just decide if a demand is made under the statute, we don't have to provide it to them. We'll fire them. We just fire them.
What's wrong with that construction?
The purpose of that is the statute's not limited to the fact that they can fire you. You can be fired. They can fire Mr. Captain Gardner, and they have. But the legitimacy of the investigation, which they are using to support the termination, which will be heard at a personnel board, is the only remedy for a law enforcement officer in the Policeman's Bill of Rights is injunctive relief. There is no damage claim. It's solely the enforcement of the statute. And so what their argument, and I think I've read it, is that we can just fire you, and we don't have to give you the rights under the statute. And it's a procedural process.
I would agree that you could make a really good argument, I think one that at least resonates with me, that you can't strip someone of all their rights by leaving, let's say, the right to notify them of a right to a hearing, perhaps, and then with regard to alleged things that they have done or not done. And you can just skip over all that and just fire them. Maybe there would be some right to injunctive relief to require them to conduct that hearing. But where the right that we're talking about is the right to have, I'm going to use this shorthand term, realizing that it's not limited to this, but let's say the right to have an unbiased investigator investigating you, the officer, and there is no one investigating you, the officer, anymore. If that's what a statute is designed to do, to ensure that any investigator is unbiased and not acting intentionally in a wrongful way, and there is no investigation anymore and no investigator, then I still wonder why it isn't moot.
Well, Your Honor, it wouldn't be...
As to that particular right.
Sure. Let's change it and talk about rights in general then.
I didn't want to talk about rights in general. I wanted to talk about this right to have what I'm using shorthand, an unbiased, fair investigator, so that we're having an ongoing, unbiased, fair investigation. Either it was fair or it wasn't, but it's done.
It would be the same argument, Your Honor, if, for instance, a simple Fourth Amendment violation in an arrest. We unlawfully searched and seized documents. And, Your Honor, we got a conviction. And the conviction was done. There's no longer a trial. There's no longer an examination. We got the conviction. We don't need to go back and determine whether his rights were violated. Trial's over. We got a conviction. So let's just forget about it. That's the whole mindset behind we don't have to follow due process, not substantive, but we're talking about procedural due process, because what we did is just jump to the end. We can bypass all of this procedural rights by coming to a conclusion. And in all the rights that we have. So if we jump to the conclusion, isn't it all moot? If we are willing to,